Good morning, beautiful people, or good day. I don't know when you're listening to this,
It'll be a Wednesday.
welcome back to another episode of Black Parents Aging. We are so delighted to be doing the show again and to be back in another great season. I hope you have been checking out our episodes, and today we have a good one for you. You ready, Liv?
I'm ready. And look, this is our first episode together. We've been doing
Yeah.
stuff separate. So I'm excited for us to be back in the seat together. Um,
So today, guys, we are talking about guardianships and conservatorships. I wanted to do this episode because we get so many phone
yes.
calls from families where mom is aging or dad is aging, and the solution is, oh, we need to get a lawyer, we need a guardianship, or at least that's the perceived solution.
Yes.
And so I don't know that families often understand what goes into pursuing a guardianship petition with the courts. And so I wanted to have Liv is our in-house expert on this subject. So I'm going to
Let's
interview
see what
her.
I can do.
I'm going to interview her so you guys can kind of hear a little bit more
Yeah.
about how that works. Okay. So, Olivia,
Yes,
how
ma'am.
how many guardianships will you say you?
Oh, I'm getting close. I would say between 50 and 75, maybe at this point.
So you are definitely not new to this.
No, not new to this. Not new to this.
And so explain for our listeners, what is a guardianship? When somebody says, I need to get a guardianship, what are they referring to?
So I don't know what they're referring to, but I will tell you what it is. It is you asking the court to step in your loved one's shoes and make all the decisions for your loved one because they don't have the capacity to make them for themselves. And so sometimes people get really confused about guardianship and conservatorship. And I try to tell people that call our offices, guardianship is of the person. So anything having to do with that person, what they're going to eat, making sure they have all their personal effects, where they're going to live, those things are for guardianship. Conservatorship is of the things. So managing their money, if they have assets, if they have bank accounts, making sure their finances in order, making sure that bills are paid. That is what a conservatorship entails. And so sometimes people need one or the other, and then sometimes people need both.
And that's Georgia. So some
That is
states,
Georgia, yes.
we have listeners everywhere. Some states have different names for these particular roles. But here in the state of Georgia, we have designated a conservatorship for the assets and the money and a guardianship for the person. And so I just want to clarify a point you made. It's you, the loved one, asking the court to allow
Yes,
you to step into this person's shoes. Is that
yes,
correct?
that's
And so
correct.
you,
And the
the loved
court
one,
may or may not grant you that, or they may grant you not the full authority that you are asking for. And so that's why it always requires a hearing.
got it. So let's talk about it. So from step one, so somebody calls our office, they
Yes.
say, Mom, mom is wandering around in the streets. We'll just use that as our example today. And I need a guardianship. So you sit down with them, talk about what a guardianship is, and there is a petition that is
Yes,
filed with the court,
that is
correct?
correct.
So
That is correct.
once that is filed,
I'm sorry.
what happens once the petition is actually filed with the
So once we file the petition, then the court is going to do a couple of things. The court is going to appoint your loved one that you are asking for a guardianship for an attorney. And so that attorney is going to represent that person's interests. The person is also going to send out an independent evaluator, could be a
the court?
social
The court is gonna
worker.
send out-
I'm sorry, go
the
ahead.
court that sends out the evaluator?
Yes, the court
Okay.
is going to send out the evaluator. And so what happens is they want someone that is independent of this situation and family to go out and evaluate the condition of the person that you are saying needs a guardianship or a conservatorship. That person goes out, Oftentimes they talk or try to talk to the person. Sometimes the people are nonverbal. They'll talk and interview people who are there in the house, and then they'll come to a conclusion on whether they feel like that person needs a guardianship and conservatorship, and they'll submit an evaluator's report.
Mm, okay, so we're gonna use mom for our example, because I think
Yes.
it's cleaner. So mom, you said, gets her own attorney. What's the role of her attorney? If she's wandering around in the streets,
Yes.
she need her own
So
attorney.
attorneys are client led. And so when mom gets an attorney, if mom's like, I don't need a guardianship, I don't need a conservatorship, I'm just fine. That is that attorney's job to represent and advocate on behalf of his or her client, what their wishes are. In some cases, because of that, there will also be appointed a guardian ad litem.
So what's
The guardian ad litem's job is to look at the best interest. So not necessarily what we call in Georgia the proposed ward, which is the family member that you're asking for a guardianship for, not necessarily what they want, but looking at the totality of the circumstances. What do they believe would be in the best interest of that person? And so sometimes a case needs both. And sometimes it is sufficient for there just to be an attorney for that person.
so who excuse me, who does the guardian ad litem work for? Like, whose position are they representing?
They're independent.
Okay.
They work for the court. The court
Okay.
has appointed them, and the judge wants to know what their opinion is. And so oftentimes that guardian ad litem talks to all the parties. They talk
Okay.
to the person asking for the guardianship. They talk to the attorney or the person that they're saying needs a guardianship. And then if there are other family members or other people, they'll talk to them as well, trying to get a full picture of what's going on so they can provide the best feedback or the best the best opinion to the judge as to what they feel like would be in the best interest.
So it sounds like the guardian ad litem is kind of the judge's eyes and ears, since the judge can't get down on the bench and do all these things. It's the investigator essentially for the court. Is that a
That is
fair?
accurate. I mean, I would
Okay.
say that the guardian ad litem and then the evaluator, because the evaluator's report gets weight too. The judge wants to know, okay, what is this independent person? When they went out, what did they see? What do they think? So I think those two positions are really the eyes and ears of the court, and gives the court a better understanding of what's going on without any without any opinion or any other influences coming in. Just what they see, hear, and observe, and giving that to the court.
So once the guardian ad litem's involved and this independent investigator, you said it almost always has to have a hearing,
Yes.
correct? Okay, let's talk about that hearing.
Oh my gosh. So I will say this, there are two types really of guardianship conservatorship. There are the kind that are really not contested, because the proposed ward, your loved one, is in such shape that they can't even contest. They may not know what's going on. They may have they may be aging. So it may be someone that has dementia or Alzheimer's, or it's just aging and not able to manage their life anymore. Or it could be someone with developmental disabilities. So someone that has autism that is extreme, or someone that has Down syndrome. And so in a lot of these situations, it is obvious why they need guardianship or conservatorship, and it's not really a contested matter. And so for those hearings, it is just a matter of the court getting the evidence, right? So of the court hearing what this person's diagnoses are, what their day looks like, why they need someone, why they can't manage their lives themselves. So that's the first one. Those are a lot easier. I will say the challenge with both, though, is that person is sitting there. So
So
different when
let me just
someone
ask, you
passes
said they're
away,
sitting, yeah, they're sitting there, so they're
listening.
hearing all of this.
Yes.
So,
and that's hard because there you need to put these facts into evidence so that you can get the guardianship, but oftentimes you're not saying nice things about that person, and so that person is sitting there listening to all of the things you're saying about them. That is difficult. Then the second type of guardianship is a contested guardianship, and that is where either the proposed ward, your loved one that you're saying needs a guardianship, is like, nope, I don't, and we're putting up a full defense, or there are other parties. Maybe there are, and I'm thinking of one I had maybe a year and a half ago where there were multiple children wanting to be the guardian of dad, and they were fighting about who would be the best guardian. And so you have these different parties in court saying the worst things, not just about dad, but about each other, as to why they are more fit than the other person to serve in that role. And so it can get heated and it can get ugly, really quick in
mm.
hearings.
And I think that that is the part that people don't necessarily think about. They think
Yes,
that we're just going to ask the courts and they're going to give us this piece of paper and now we're going to be in charge and it's going to be fine, without really understanding the process and
yes.
understanding how this is going to affect your family dynamics in the long run.
For sure. I'll tell you, I had someone come in late last year that definitely needs a guardianship just from the facts and the things that they said were going on. And I'd given them the process in the beginning, but then when we were ready to file the petition, it got real. Like, you're gonna have to testify. Your dad is going to know that you know, are the one asking for guardianship. You're the one saying that he needs it, and you are the one saying these things about him or telling the court like what is going on. And they backed out,
Mm,
because she said, this is going to change my dynamic with my dad. Like, he's not even going to let me in his house. Like, he's not going to talk to me. Like, he's going to be upset with me. I can't, can somebody else do it? And so it really does have the potential to change those family dynamics.
mm,
And sometimes they're absolutely needed. Whether it's going to change the dynamics or not, it's a safety issue. Like, they are definitely needed, but we should not gloss over that there are other effects that maybe you haven't really thought about or know
mm.
that is going to come from that.
Got you. So, what happens once the guardianship is granted? Like,
Yes.
what does that mean? Because it is really just a court order, right?
It is a court order. Once the guardianship is granted, so oftentimes family members are having a difficult time doing something. So they're having a difficult time with doctors and they don't really know what's going on with the diagnoses. They're not allowed, back in the doctor's visits. They aren't sure about medication. And so they need to have all of that information. And so once they get that court order, then they can carry that court order around to all of the places where they need to be involved and to have more information and say, hey, I'm his guardian. This is the authority that the court has given me. This is the information I need, or I need to be included, or I'm going to be at all the doctor's visits now. Same thing with conservator. They may need to go to the bank and say, hey, I'm going to be taking over the finances. We need to open another account. Here's the authority the court has given me. So usually people come because they are having some sort of difficulty with helping a loved one in some aspect of their life. And that court order allows them to then be able to step in and help or manage that part of their life.
Gotcha. So let's talk a little bit about that order because I think sometimes people don't understand really what it means when there is an order of guardianship in place. The person, the proposed ward, no longer has certain rights. Do you want
Right.
to talk about what that means and
Yeah.
what they're having to give up when that
Yeah.
order is in place?
So it depends.
Mm,
It depends on how much authority the judge gives you. but some of the things that you may give up, your right to contract, you can't
The
sign
ward. So the person.
the ward,
Yeah, okay.
the proposed ward would give up their right to contract. Like they can't sign and say, yeah, let's have some sort of agreement. They can't do that anymore. I was reading through one because I'm working on a couple now. Their right to enter into a marriage, like, their right to vote could be affected. Their right to drive, so their ability to drive. So like every aspect of their life, depending on what that particular order says, can be interrupted by those letters of guardianship, as they are termed.
So even the right to vote, as I understand it, could be a potential one. So when I explain it to families, I sometimes think about or explain it as all the rights we got as part of coming of age, as part of becoming an adult, like the right to drive, the right to bear arms, the right to
Right,
vote.
that's another,
Right?
yep.
We're essentially stripping those away.
Yes.
And so I think people have to understand like how serious this is. We are reverting this ward, if you will, to almost a childlike status.
Yes.
Need a parent to take
Mm-hmm.
care of them now.
That's exactly what we're doing. And you know, depending on the condition of the proposed ward, the court may or may not take all of those away. I just had a hearing where he was like, I'm going to leave the right to vote. Like the proposed ward still can vote. And so they may leave certain rights in depending on what they think is needed. But the court is also looking at the least restrictive measure. They want the proposed ward to be safe. They want to make sure that that they are provided for. But if they can do that short of stripping all the rights away, then they will. And so sometimes family members don't understand that either, that yes, your loved one has dementia and yes, they need help, but the court is also looking out for them and their rights. And so if there is a way to protect this person and keep them safe without stripping all of their rights away, the court is going to try to do that.
Okay. So that's guardianship.
Yes.
Well, we'll come back if we need to, but
Okay.
let's transition a little bit. Let's talk about conservatorship because
Yes.
define the two, but I don't know that people fully understand how these two roles are separated.
Yes.
So from a court standpoint, is it the same person as the guardian that is the conservator? Do we appoint somebody different? Is it somebody the court brings in, or is it a family member? How does that work?
It can be all of the above. So
Mm.
a guardian and conservator can be the same person.
Okay.
It can be someone different. The guardian can, and oftentimes in families, they try to divide and conquer because they know that the person that is going to be the guardian is going to have a lot of responsibility. And so if there's someone else that maybe can take on the responsibility of the finances, then they do that. So sometimes they split just so one person won't have all of the responsibility. Sometimes if the court sees fit, or even if the family is really honest, a family member may be the person that is the guardian, and they may ask the court to appoint a county conservator. Especially if there is if there are complicated finances or lots of assets that need to be managed. Sometimes the court will appoint someone to be over that, and a family member to be over the guardianship in the person. So it can be made up several different ways. Sometimes, which is in the case that the contested case I had, the court was just like, y'all are fighting. I can't trust that any of you will get along with the other well enough to be in the position. And so I'm going to appoint a county guardian and conservator. So in that contested matter, the court appointed objective parties for guardian and conservator, did not appoint a family member for either. So just depending on the circumstances and the facts of the case, any of those can happen.
So you said county. So that person, the county conservator or the county guardian, they work for who? The court, the family? Where
The
do they?
court. So they are an objective party. They are appointed by the court. They report back to the court. They obviously have to interact with the family and all the parties and try to mediate and manage any tensions or any issues there. But their job is to look out and to serve the best interests of their client, which is the proposed board in that case. And so they are appointed and they have to report to the court. They're always looking out for what's going to be best for the proposed ward, but just because of their position, they will be interacting and dealing and talking with family members as well.
So who pays them? Where, I mean, this is a job, right?
So yes, it is a job. And for a conservator, depending on what is the assets of the ward, it can be paid out of there. It can be paid out of whatever those assets are. They would get a portion of that. But yes, they have to be paid.
Mm-hmm.
This is not a volunteer job. They definitely have to be paid.
Okay. So let's talk about like you get this order in place, you got this conservator, you got this guardian, then what? Like you just ride off into the sunset? How does the court know that you're taking care of these people or that you're not just spending their
Yeah.
money and, you know, going to Vegas to see Usher?
If it were only that easy to ride off in the sunset. So part of the conversation I have when people come in and say they want to be a guardian and conservator is the reporting requirements. And the reporting requirements are serious, and the court will hold you in contempt and ask for a hearing if you do not comply. And so once you are appointed guardian and conservator, you have 60 days to file a report with your initial report with the court. So if you're a guardian, that is a personal status report. The personal status report says, hey, this is how the proposed ward is doing, or at this point, they're the ward. This is how they're doing. This is the last time they went to the doctor. This is the medicine they're taking. These are the diagnoses. You know, this is what they're doing on the day-to-day basis. Just a report so the court has an understanding of how that person is doing. If you are a conservator, there is a financial management report that you need to financial management plan that you need to file with the court. So not only here is a list of the assets, but here is my plan for those assets. Am I investing them? Have I put them in a high yield account with a bank? Am I renting out, if the person is no longer in the house, am I renting out the house? Are we taking income? Here is the plan for those assets, and I'm filing it with the court. So that happens 60 days after you are appointed guardian and conservator, and then annually. So once a year, you have to report to the court on those two things. If you're guardian, the personal status report. If you're a conservator, the financial management plan. You have to report to the court. So the court is overseeing you as guardian and conservator for as long as that lasts. So it either lasts until that person passes away, or it lasts until they don't, maybe something happens and they don't need it anymore, a miracle. And they may ask for it to be dissolved. So until one of those things happen, you are reporting to the court at least annually.
Mm. So what about the proposed ward's assets? Like if you needed to use them or sell the house or, you know, they needed, I don't know, trip to Vegas. I keep going to Vegas. How can you just
Yeah.
write checks and, you know, do that?
So with the what I try to do is if there is anything foreseeable. So when you're having the hearing, you're telling the court, okay, these are the expenses. This is how the money gets spent. This is how much comes in in a month. This is how much gets spent. If there is anything outside of the normal expenditures, you're going to need to ask the court for it. And especially if you're going to sell the house or something like that, you're going to need to ask the court for permission to do that. So the court is always overseeing what is being done because they want to make sure that even though that person is in a vulnerable position, they can't make decisions for themselves, that the person that they have appointed is always acting in the best interest of that ward. And for me, if there is anything that we can foresee, when we have the hearing, we go ahead and put that into evidence, put that in the record, and ask the court then, so that we don't have to keep coming back to ask for additional things. But there are things that always pop up that you perhaps would need to ask the court for permission for. But anything out of the normal spending, out of what we've already put in evidence, what the court has already approved, you're going to need to ask for permission.
So we're about to wrap up, but before we do, because I want people to really understand guardianship and conservatorship should almost be a last resort. Now,
Yes.
help me to just explain to the people before we jump to let's go file a petition, kind of what should they be
Yeah.
doing, thinking about before that?
So, it depends. And I ask, okay, I usually ask clients that we have, okay, well, what are you doing now? Are there people coming in the home? Are there home health people? Are there people that can sit with them? Are there adult day programs that you've put them in? What are other ways that have you tried to maybe have someone living with the person, a companion that can help out and keep an eye? Are there other things that don't strip them of all of their rights that we can put in place to assist and provide the help they need without jumping right to guardianship? Depending on their insurance, does the insurance pay for certain things? Are they a veteran? Does that mean that there are certain things that they pay for that under that? So you want to explore all of the options, and make sure that you have tried and exhausted all of those possibilities, or at least some of them, before you get to the point where you're like, nope, we just need a guardian. And
So
so
you go to court, do they have to testify as to what they've already done? Because the
you
courts
do.
see that you have already exhausted everything, and that's how we got here.
That you've tried, or that it is just such dire that there is no way that any of that will work. And so you have to get on the stand and you do have to testify, because the court does want to hear from you, and they want to make sure that if they are putting this in place, that this is the last resort, that there is nothing else that has a possibility of working, short of a guardianship and conservatorship.
All right, I think that's all my questions.
Yay! And I was able to answer them.
I don't know that I have any more regarding guardianships and conservatorships, but anything else that you want to make our audience aware of before, because there might be somebody listening
Yeah.
right now that's thinking about, okay, it might be time to call a lawyer's office and see about getting a guardianship or a conservatorship.
I think we've covered it, but just understanding what that process is, and understanding that you are going to have to testify in front of that loved one. And then the other thing, just making sure that there isn't another alternative route, before we even start down that road. And if there's not, there's not. And, we're happy to help. But if there is, try that first. And then if that doesn't work, then give us a call.
All right. Well, this episode was just about adult guardianships. Now,
Yes.
this does handle minor guardianships. And maybe we'll do another episode next.
Temporary minor guardianship. Yeah, that may need its own.
Yes. So there are circumstances that bring us to court when we
Yes.
need temporary minor guardianships or even minor conservatorships.
Yes.
Maybe that minor has inherited money from someone who passed, or a life insurance policy that was left in their name. So there's a whole nother host of reasons why a minor might be in this predicament, or need a conservator or guardian. But that's not for this episode. That's for another one. So we will definitely come back to this topic and explain that to you guys, because we get them all the time where auntie left money to niece or nephew and they're only 4 years old.
Yeah.
What do we do then? So that's another topic I think that the audience would probably benefit from hearing, and
That's a good idea.
why it's probably not the best course of action to leave funds to a minor without having some other things in place. Well, thank you, Olivia, for this interview.
I'm happy that we got on together. We've been it's been busy. We've been trying to just manage, but I'm glad we'll have a few episodes this season together. So
Yes, I look forward to that. Thank you guys again for tuning in. You know what to do. Leave us a review. Leave us any comments. If you have questions, you know how to
Yes.
reach us. Most of our topics come from people on who listen to us or from our clients. So we
Yes.
really appreciate the feedback and your willingness to give us ideas for this show. That's it for now.
Bye, y'all.
Guys.